Thank you, Chairperson. We are really lucky to have Justice B.P. Singh here because I think there are, as Mahesh has reflected, there are important considerations that judges have in mind when they adjudicate issues of such important nature. And obviously, not everybody can make everyone happy. So there will always be people with specific concerns and specific interests that may find inadequate sensitivity or inadequate response from any institution, including the judicial institution. But I thought that we were here really to look at something much more specific to the economic impact of decision making. But inevitably what has happened is that we've spread ourselves a little bit more into the nature of judicial decision making, which by itself is a very, very important subject in a democracy. I just want, and I'm sure that Justice B.P. Singh will find this interesting as well. There is something that everyone seems to have lost sight of that's very significant and very critical to the concerns that you are expressing here. And this is the advisory opinions of the Supreme Court in the 2G matter. If you recall, in the 2G matter, there was a 2 judges bench that was handling what is being described as the 2G scam, but the entire 2G saga, if I might put it like that, was being handled by a bench of 2 judges of the Supreme Court. They are the ones who were responsible for indicating that there were illegalities and irregularities because of which 122 licenses were set aside, and obviously other implications such as criminal prosecutions were launched, being monitored by the Supreme Court itself. But that's one part of the saga. Within government, the point that has just been made about investments, not just investments within the country, but investments that have come from investors beyond the country's borders, and India's own profile in terms of confidence that global investors have in India. Keeping that in mind, we had at the time of the request to be made by the President to the Supreme Court for an opinion, the Cabinet had considered what all should be put in, and we had actually put in 9 questions, which had gone to the Supreme Court. Supreme Court, in its judgment, in the opinion, said we will answer 5. So the others were obviously questions that could be answered by division benches later, but the larger perspective and the larger issue was to be answered in terms of 5 questions. And I will just tell you what those questions were. They said that 5 questions which are as follows. Keeping in view the government's statement, the present bench declined to answer the last 3 questions, which were spectrum specific, so they related a lot more to the matters that were going on before the specific bench of 2 judges, but entertained the first 5 questions, which were as follows. This is what the Supreme Court said. Whether the only permissible method for disposal of all natural resources across all sectors and in all circumstances is by conduct of auction. That was first critical question. 2, whether a broad proposition of law that only the route of auctions can be resorted to for disposal of natural resources does not run contrary to several judgments of the Supreme Court, including those of larger benches. 3, whether the enunciation of a broad principle, even though expressed as a matter of constitutional law, does not really amount to formulation of a policy and has effect of unsettling policy decisions formulated and approaches taken by various successive governments over the years for valid considerations, including lack of public resource and the need to resort to innovative and different approaches for the development of various sectors of the economy. 4, what is the permissible scope for interference by courts with policy making by the government, including methods for disposal of natural resources. These 4 questions were answered by the court. And I believe to your satisfaction in industry, they were answered by the court. And I think certainly it was to the satisfaction of government, because the court said that auction is not the only method. Not the only method. It could be a preferred method, it could be a possible method, but it is not the only method. The only thing is, whichever method you choose, ultimately the courts will retain a right, and obviously they must, to test that method in the given circumstances against requirements of the Constitution. But very clearly, whatever a bench of 2 judges had said, that you are wrong because you didn't auction. Auction is mandatory. And many other things followed. There may have been other factors also, but many other things followed from that pronouncement that you were wrong because you didn't auction. Because you didn't auction, we can imply motives, we can imply irregularities, we can imply various other things, but that's, as I said, a different part of the story. Now, critical, 5th question that the court didn't answer. It said we are answering it, but failed to answer. The 5th question is whether, if the court holds within the permissible scope of judicial review that a policy is flawed, is the court not obliged to take into account investments made under the said policy, including investments made by foreign investors under multilateral, bilateral agreements? Because the court didn't answer this, because the court didn't take this into account, we are today faced with at least 20 international arbitrations that will, over the next 3 to 5 years, bring a huge liability to our country. And whatever the implications would be about people's perception, and what the judgments in those international arbitrations that can't be challenged anyway, what judgments in those international arbitrations will do to our desire that we invite more people to come to India to manufacture and to make their product here, make in India. What will happen to our attempt to do this? Now, this is interesting for you because everybody's forgotten that this question was to be answered. And as I was saying to you, Judge, many of these things happen because of the pressures that judges have. There was a retirement again. Inevitably, because we retire the judges too soon. I'm sorry, I have this feeling that we do retire you too soon. At 65, nowhere in the world, forget about judges, does anybody retire at 65. But the judges here retire at 62, and then they retire at 65, which I personally think is a terrible thing. I tried to change it, but it didn't work. I think Supreme Court judges should stay till 70. But anyway, even at 70 you could have pressure. So the pressure of retirement caused this judgment again to overlook a very critical question. And then in order to answer this question, in order to answer this 5th question, you'll have to have another bench of 5 judges. And all 5 who gave this would have retired by then. So you'll have 5 judges looking at it de novo, and then making greater complication for the law by maybe coming to a different conclusion from these 5. But they're only supposed to look at one question because that's the question that remains unanswered. But this is the problem with the institution. And I think this 5th question answers many things that you have raised, provided that 5th question answered it and then it was applied. Now, you've talked about protocol and decency in addressing issues of courts. I think if 5 judges of the Supreme Court feel something should be done in a particular way, 2 judges of the Supreme Court, even if they had decided that it should be done differently, should have then said that we will bow to the 5 judges and we will change our position. They were not bound to, because this was an advisory opinion, but I think if you just look at the nature of the institution, if 5 judges, including the Chief Justice, says auction is not necessary, 2 judges say, but we've already said auction is necessary. And a whole generation of investors have been I use the word traumatized by the consequences that 5 judges have said should not have happened in the first place. The other issue is, you missed the best points. This is an Indian the other important points that I might mention, and I think that concerns also what Sandeep said, and I think Naveen will say, is that in this entire saga, right or wrong is separate to judge, but in this entire saga, nobody in coal or in 2G, nobody has stood up and said, look, our law allows that there should be no discrimination, mandates that there should be no discrimination. I was also in the queue, and I was also expecting, and I was higher up or further, I wasn't given it, therefore you should take away what you have given to them. Not a single person has said that. In 2G, not a single person has said that I would have got it if you hadn't interfered with the order. I'm not saying that the interference with the order was right or wrong, because the matter is sub judice, but nobody said that I was in the queue, because something was done, they pushed me back and I didn't get a license. Everybody got a license, including those who are questioned, those who are not questioned, those who were found prima facie to have done some wrong, those who were not even considered having done any wrong. Somebody who was 6th in the queue got the license at number 8. Somebody who was 8th in the queue got the license at number 1. But the amount of money they paid was the same. And not a single person stood up and said, I didn't get a license. If he had not got a license, then he could have said, you set aside all these licenses because I must get my license. So the confusion in 2G was between what has the government or the state lost. Because if the state has lost, then you don't even need to look at whether somebody made a mistake or not made a mistake. If the state has lost is important, then you have to set everything aside, including you. But if the state has not lost, then you can't look at these things unless there is a personal culpability or a personal responsibility. What has the state lost? Now, Hari, you said something about a notional loss. You know, I'm suffering a notional loss by being here because I'm missing 2 clients this morning. But I mean, I hope that I'm being compensated by being here.
And also gain of having 10 more clients.
By having such distinguished, being in such distinguished company, and certainly in company of Justice B.P. Singh, that it's an honor to be with. But this whole concept of notional loss is the scam. That's the big scam, notional loss. Because, and I want to share this as a personal narrative with you. When this 2G thing was blowing up, I was with some friends one evening for a birthday party, environmentalists, and they were all arguing about Supreme Court and Camper Fund and environment and so on. And I said, look, somebody's sitting here, let's ask him what about this 2G. And Kapil Sibal was sitting there. And so he said, okay, I will tell you what's happened in 2G. And he explained the entire, he wasn't the minister obviously when this happened. He took over later on to sort out things. And he explained the entire saga, starting with what the Planning Commission papers were on telephony. And he said the Planning Commission's primary concern was not revenue generation, as far as this paper is concerned. It was not revenue generation, it was penetration, affordable telephony, so maximum coverage in the country. And if that was the Planning Commission's objective, that objective has been met, because at that time there had been an explosion of right? Same as coal. I don't know coal that well because I've now become a lawyer. Then I don't take any of these. Yeah, but I don't consider any of these things unless you pay me. But that one I considered because we were supposed to look at them in public interest. But no, I understand. It's the same thing. What was your purpose? What was your purpose? if you came to my shop saying, I want to buy a pen, and I gave you a pen, you can't go back and complain that it doesn't write like a pencil. Because you should have come and asked me that I want a pen that writes like a pencil. In which case I would have given you something that looks like a pen but has a lead, a pencil lead. Whereas you asked for a pen and I gave you a pen. So you ask the wrong question, you will get the wrong answer. You ask the right question, you will get the right answer. I think this is the basic principle of logic and basic principle of communication and basic principle of decision making. I think this is where our generation has really suffered a major confusion. Now, how will this confusion be sorted out? We were, as a party, incapable of sorting out the confusion, so we were shown the door. And we were told, you're no good, you create more confusion, now you go and rest for a while. So a new party was brought in. And a new party was brought in by telling people, these are confused guys, they should go, we will solve the problem. Now you're telling me, this lot is also confused because they're making a greater confusion. Now, I think frankly, this is happening because there isn't enough open debate. There isn't enough open debate for two things. One, sir, that I would want you to consider, we don't give you enough information in the court. What Americans call the Brandeis brief. They let lawyers argue for only half an hour each side, and then the light goes on in the Supreme Court, in the American Supreme Court. You have to stop midway of a sentence when the light goes on. You can't say the next word. Here, when judges ask us, so how many days do you want? And we say 16 days for arguments. And the other guy says, this guy said 16, I must say 18. So he says 18 days. And then the arguments go on for months on end, day after day, day after day, day after day, and every day new papers are given, but we don't give something that's called a Brandeis brief. Planning Commission had some of the most brilliant people in this country at the time when these issues were being raised. Coal was being raised, food was being raised, issues of 2G were being raised, and not a single Planning Commission document was made available to the Supreme Court or allowed Planning Commission asked to come to explain what was the context in which these decisions were being taken. How does anyone take a view about economic decisions unless somebody who is responsible for those decisions can come and provide that material? So I think that's one problem. The second issue is that we don't have informed public debate. I've been in government. I saw some of the auctions that happened in 2G. I don't know whether there is an argument today to say because there were 2G auctions, therefore the entire economy of telephony today is better than the economy of telephony it was before 122 licenses were cancelled. I don't know. Perhaps some of you would know, because I do know the first couple of auctions failed because nobody was willing to come. There wasn't money in the market. Banks were not willing to lend. There was uncertainty of whether even with an auction somebody else would not change the policy, etc., etc. We were trying to shore up the price that we could get from the auction by not giving out the entire spectrum at the same time. So whatever spectrum was available was being reduced artificially so that we could get a better price, and there were a lot of technical issues as well. If somebody would do a open public debate and give the information, tomorrow a judge of the future in the Supreme Court would know that when we look at this and we look at the economic implications of the decisions that we take and have taken, really we need to look at the following factors. So there is no such thing, if I may submit, as an economic analysis of law in India. In the American jurisprudence, there is a huge segment called the economic analysis of law. Law is about morality, law is about instinct, law is about a shared sense of values, law is about the technical laws that are conducted, laws is about powers that are distributed to different institutions, including separation of powers and so on. But law is also in modern times about economics. And as we were talking, Justice B.P. Singh was saying that before the SEBI appellate tribunal came, and when he was in the High Court in Bombay, you said those matters used to all come to the High Court, and the High Court had to decide. And this is where the big new question has arisen of tribunals, that should you have experts looking at these things, presided over by someone who has judicial knowledge, or should it be entirely people who are generalists like lawyers and judges, but with some perhaps background and experience? Because when you look at competition law, for instance, it's all about the marketplace. Now, are we as lawyers equipped to handle the instruments of the market? For that matter, financial institutions, or you require specialists? And how can you add specialist knowledge to the common law system of deciding cases, where there was a great virtue in being a generalist? Because it was felt that if you were too much of an expert, you would not be able to look at the larger picture of what is just, fair, and good for society. But today, it seems, and I hope that we will hear from Justice B.P. Singh about the penetration of expertise, technical things into the area of law, and how that could be decided. Thank you very much.